Om Namo Bhagavate Vasudevaya. Seven. Dishonor of check for insufficiency of funds in the accounts section 138 to 142. Dishonor of check for insufficiency etc. of funds in the accounts section 138. Where any check drawn by a person on an account maintained by him with a banker for payment of any amount of money to another person from that account for the discharge in whole or in part of any debt or other liability. A check given as gift or donation or as a security or in discharge of a mere moral obligation or for an illegal consideration would be outside the purview of this section is returned by the bank unpaid, either because of the amount of money standing to the credit of that account is insufficient to honor the check, or that it exceeds the amount arranged to be paid from that account by an agreement made with that bank. Such person shall be deemed to have committed an offence and shall be punished with imprisonment for a term which may extend to 2 years, or with fine which may extend to twice the amount of the check, for with or with both. Then section 138 shall be not apply unless the below given conditions are complied with. Check presented within validity period. The check has been presented to the bank within a period of 3 months from the date on which it is drawn, or within the period of its validity, whichever is earlier. Demand for the payment thereof. The notice, the payee or the holder in due course of the check, as the case may be, makes a demand for the payment of the said amount of money by giving a notice in writing to the drawer of the check within 30 days of the receipt of information by him from the bank regarding the return of the check as unpaid, and failure of drawer to make payment. The drawer of such check fails to make the payment of the said amount of money to the payee, or as the case may be, to the holder in due course of the check within 15 days of the receipt of the said notice. Explanation. For the purpose of this section, debt or other liabilities means a legally enforceable debt or other liabilities. Therefore, we may conclude that com- compliant compliant can be filed after 45 days of dishonor of the check, that is 30 days of notice period plus 15 days of the receipt of the said notice. Example: X issued a post-dated check to Y on the account of discharge of its liability. Further, X entrusted to the bank to stop the payment due to unavailability of the adequate amount in the account. Here, in this instance, Section 138 of the Act is attracted as when a check is dishonored on account of stop payment. In instructions sent by the drawer to his banker in respect of a post-dated check, irrespective of insufficiency of funds in the account. A post-dated check is deemed to have been drawn on the date it bears, and the 3 month period for the purposes of Section 138 is to be counted from that date. So, X will be liable for dishonor of check once a check is issued by the drawer. A presumption under Section 139 must follow. Penalty: according to Section 138 of the Act, the dishonor of check is a criminal offence and is punishable with imprisonment up to 2 years or fine to twice the amount of check or both. Presumption in favor of holder. Section 139. When a check is dishonored, it shall be presumed, unless the contrary is provided, that the holder of a check received the check of the nature referred to in Section 138 for the discharge in whole or in part, or any debt or other liability. Presumption prescribed here is a rebuttable presumption, has the provisions clearly provides that the person issuing the check is at liberty to prove to the contrary. The effect of this presumption is to place the evidential burden on the accused. Defense which may not be allowed in any prescription under Section 138, Section 40. It shall not be a defense in a prosecution of an offences under Section 138 that the drawer had no reason to believe when he issued the check that the check may be dishonored on presentment for the reasons stated in that section. 8. Presentment of instruments. Presentment of for acceptance. Section 61. A bill of exchange payable after sight must be presented to the drawee thereof for acceptance by a person entitled to demand acceptance within a reasonable time after it is drawn, and in business hours on a business day. In default of such presentment, no party thereto is liable thereon to the person making such default. If the drawee cannot, after reasonable search, be found the bill is dishonored, if the bill is directed to the drawee at a particular place, it must be presented at that place, and if at the due date for presentment he cannot, after reasonable search we found there the bill is dishonored, where authorized by arrangement or uses, a presentment through the post office by means of a registered letter is sufficient. Presentment of promissory note for sight. Section 62. A promissory note payable at a certain period after sight must be presented to the maker thereof for sight by a person entitled to demand payment within a reasonable time after it is made, and in business hours on a business day. In default of such presentment, no party thereto is liable thereon to the person making such default. Drawee's time for deliberation. Section 63. The holder must, if so required by the drawee of a bill of exchange presented to him for acceptance, allow the drawee 48 hours exclusive of public holidays to consider whether he will accept it. Presentment for payment. Section 64. Promissory notes, bill of exchange and checks must be presented for payment to the maker, acceptor or drawee thereof, respectively, by or on behalf of the holder has hereinafter provided. In default of such presentment, The other parties thereto are not liable thereon to such holder, where authorized by agreement or usage. A. Presentment तरफ the post office by means of a registered letter is sufficient. Exception where a promissory note is payable on demand and is not payable at a specified place, no presentment is necessary in order to charge the maker thereof. Notwithstanding, after anything contained in section 6, where an electronic image of a truncated check is presentment for payment, the drawee bank is entitled to demand any further information regarding the truncated check from the bank holding the truncated check in case of any reasonable suspicion about the genuineness of the apparent tenor of instrument, and if the suspicion is that of any fraud, any forgery, any tampering, or any destruction of the instrument, it is entitled to further demand the presentment of the truncated check itself for various verification, provided that the truncated check so demanded by the drawee bank shall be retained by it if the payment is made accordingly. Hours for presentment. Section 65. Presentment for payment must be made during the usual hours of business, and if at a banker's within banking hours. Presentment for payment of instrument payable after date or site. Section 66. A promissory note or bill of exchange made payable at a specified period, date or site thereof must be presented for payment at maturity. Presentment for payment of promissory note payable by installments. Section 67. A promissory note payable by installments must be presented for payment on the third day after the date fixed for payment of each installment, and non-payment on such presentment has the same effect as non-payment of a note at maturity. Presentment for payment of instrument payable at specified place and not elsewhere. Section 68. A promissory note, bill of exchange, or check made, drawn or accepted payable at a specified place and not elsewhere must, in order to charge any party thereto, be presented for payment at that place. Instrument payable at specified place. Section 69. A promissory note or bill of exchange made, drawn or accepted, payable at a specified place, must, in order to charge the maker or drawer thereof, be presented for payment at that place. Presentment where no exclusive place specified. Section 70. A promissory note or bill of exchange not made payable as mentioned in section 68 and 69 must be presented for payment at the place of business, if any, or at the usual residence of the maker, drawee or acceptor thereof, as the case may be. Presentment when maker etc. has no known place of business or residence. Section 60, Section 71. If the maker, drawee or acceptor of a negotiable instrument has no known place of business or fixed residence, and no place is specified in the instrument for presentment for acceptance for payment, such presentment may be made to him in person wherever he can be found. Presentment of check to charge drawer. Section 72. Subject to the provisions of Section 84. A check must, in order to charge the drawer, be presented at the time at the bank upon which it is drawn, before the relation between the drawer and his banker has been alterated to the prejudice of the drawer. Presentment of check to charge any other person. Section 73. A check must, in order to charge any person except the drawer, be presented within a reasonable time after delivery thereof by such person. Presentment of instrument payable on demand. Section 74. Subject to the provisions of Section 31. A negotiable instrument payable on demand must be presented for payment within a reasonable time after it is received by the holder. Presentment by or to agent, representative of deceased or assignee of insolvent. Section 75. Presentment for acceptance or payment may be made to the duly authorized against agent of the drawee, maker or acceptor, as the case may be, or where the drawee, maker or acceptor has died, to his legal representative, or where he has been declared uninsolvent, to his assignee. Excuse for delay in presentment for acceptance or payment. Section 75A. Delay in presentment for acceptance or payment is excused if the delay is caused by circumstances beyond the control of the holder and not imputable to his default, misconduct, or negligence when the cause of the delay cases to operate. Present, presentment must be made within a reasonable time. When presentment unnecessary, section 76. No presentment for payment is necessary and the instrument is dishonored at the due date for presentment in any of the following cases. A. First, if the if the maker, the drawee or acceptor intentionally prevents the presentment of the instrument, or if the instrument being payable at his place of business, he closes such place on a business day during the usual business hours, or if the instrument being payable at some other specified place, neither he nor any person authorized to pay it attends at such place during the usual business hours, or if the instrument or instrument not being payable at any specified place, he cannot, after due search be found, has against any party sought to be charged therewith, if he has engaged to pay, notwithstanding non-presentment, has against any party, if after maturity, with knowledge that the instrument has not been presented, he makes a part payment on account for the amount due on the instrument, or promises to pay the amount due thereon in whole or in part, or otherwise waives waives his right to take advantage of any default in presentment for payment, has against the drawer, if the drawer could not suffer damage from the want of such presentment, liability of banker for negligently dealing with bill presented for payment, section 77. When a bill of exchange accepted payable at a specified bank has been duly presented, therefore payment and dishonored, if the banker so negligently or improperly keeps, deals with, or delivers back such bill, has to cause loss to the holder, he must compensate the holder for such loss. Rules of compensation. Rules of compensation. Rules has to compensation. Section 117. The compensation payable in case of dishonor of promissory note, bill of exchange, or check by any party liable to the holder or any endorsee shall be determined by the following rules. The holder is entitled to the amount due upon the instrument, together with the expenses properly incurred in presenting, noting, and protesting it. When the person charged resides at a place different from that at which the instrument was payable, the holder is entitled to receive such sum at the current rate of exchange between the two places. An endorser who, being liable, has paid the amount due on the same is entitled to the amount so paid with interest at 18% per annum from the date of payment until tender or realization thereof, together with all expenses caused by the dishonor or and payment. When the person charged and such endorser reside at different places, the endorser is entitled to receive such sum at the current rate of exchange between the two places. The party entitled to compensation may draw a bill upon the party liable to compensate him, payable at sight or on demand for the amount due to him, together bill all expenses properly incurred by him. Such bill must be accompanied by the instrument dishonored and the protest thereof, if any. If such bill is dishonored, the party dishonoring the same is liable to make compensation thereof in the same manner as in the case of the original will. Descriptive questions. M drew a check amounting to 2 lakh rupees payable to N and subsequently delivered to him. After receipt of check, N endorsed the same to C but kept it in his safe locker after some time and died, and P found the check in N's safe locker. Does this amount to endorsement under the Negotiable Instruments Act 1881? No, P does not become the holder of the check as the negotiation was not completed by delivery of the check to him. Section 48 The Negotiable Instrument Act 1881. M owes money to N. Therefore, he makes a promissory note for the amount in favor of N. For safety of transmission, he cuts the note in half and posts on half to N. He then changes his mind and calls upon N to return the half of the note which he had sent. N requires M to send the other half of the promissory note. Decide how rights of the parties are to be adjusted. The question arising in this problem is whether the making of promissory note is complete when one half of the note was delivered to N. Under section 46 of the Negotiable Instrument Act 1881, the making of the promissory note is completed by delivery, actual or constructive. Delivery refers to the whole of the instrument and not merely a part of it. Delivery of a half instrument cannot be treated as constructive delivery of the whole. So, the claim of N to have the other half of the promissory note sent to him is not maintainable. M is justified in demanding the return of the first half sent by him. He can change his mind and refuse to send the other half of the promissory note. Bholenath drew a check in favor of Surinder. After having issued the check, Bholenath requested Surinder not to present the check for payment and gave a stop payment request to the bank in respect of the check issued to Surinder. Decide under the provisions of the Negotiable Instruments Act 1881 whether the said acts of Bholenath constitute or unoffensive. As per the fact stated in question, Bholenath drawer, after having issued the check, informs Surinder Droy not be present the check for payment and so will give a stop payment request to the bank in respect of the check issued to Surinder. Section 138 of the Negotiable Instrument Act 1881 is a penal provision in the sense that once a check is drawn on an account maintained by the drawer with his banker for payment of any amount of money to another person out of that account for the discharge in whole or in part of any debt or liability is informed by the bank unpaid either because of insufficiency of funds to honor to honor the checks or the amount exceeding the arrangement made with the bank. Such a person shall be deemed to have committed an offence. Once a check is issued by the drawer, a presumption under Section 139 of the Negotiable Instrument Act 1881 follows, and merely because the drawer issues a notice thereafter to the drawee or to the bank for stoppage of payment, it will not preclude an action under Section 138. Also, Section 140 of the Negotiable Instrument Act 1881 specifies absolute liability of the drawer of the check for commission of an offence under the Section 138 of the Act. 140 Section 140 states that it shall not be a defence in a prosecution for an offence under Section 138 that the drawer had no reason to believe when he issued the check that the check may be dishonored on presentment for the reasons stated in that section. Accordingly, the act of Bholenath, that is, he request of stop payment, constitutes an offence under the provisions of the Negotiable Instrument Act 1881. Rama executes a promissory note in the following form. I promise to pay a sum of 1000 rupees after 3 months. Decide whether the promissory note is a valid promissory note. The promissory note is an unconditional promise in writing. In the above question, the amount is certain, but the date and name of payee is missing, thus making it a bearer instrument. As per Reserve Bank of India Act 1934, a promissory note cannot be made payable to bearer, whether on demand or after certain days. Hence, the instrument is illegal as per Reserve Bank of India Act 1934 and cannot be legally enforced.